Good evening, this is John Milburn for LAWS11057 Introduction to Law. We're into week 9 of term 3, 2018-2019. And the highlight for this week, or the low light, depending on your perspective, is that the second assessment is due on Thursday of this week, that is the 17th of January at 11:45 p.m. I recommend that you don't leave it until 11:45 p.m. to submit your work. And I'm grateful for many of you who have already uploaded your work, and thank you for doing so. Given that people have uploaded work, I need to be a little circumspect in terms of providing hints, but we will discuss some aspects of the second assessment and answer any questions that we might have. Now, Timothy had a question, do we need to include a bibliography in the assignment? The answer is no. In legal assessment work and legal work generally, we don't include bibliographies. I mean, we might in a book, but in terms of a paper that you write for assessment purposes or an examination question, we don't include a bibliography. And the reason for that is that it's not a requirement of the AGLC. So when the Australian Guide to Legal Citations. So you can include it if you wish, but do we need to include a video outlining the toolkit? That one I can't recall. So just coming back to bibliography, don't include one, but if you do, I certainly don't mind, particularly in first year. You won't receive any extra credit for it. And if it's in there, it will work towards your word count. So my recommendation is don't include the bibliography. Now, do we need to include a video outlining in the toolkit? My recollection when I wrote the assessment is no, but please someone correct me who may be more familiar with the question than I am just at the moment if I did make that a requirement. Did anyone see that? No, I thought it was only for the portfolio. Yes, only for the portfolio, so not the toolkit. Now bear in mind the toolkit is meant to be a highly useful document and useful to you. So it's got to make sense to you. I'll be assessing it from my perspective, but try to put myself in your shoes if that makes sense in doing so. So if I can understand, it may not be my logic in terms of how you've set out your toolkit, but if it appears to me that that's a logical and sensible way for you, then you're not going to lose any marks simply because it might happen to be different to the way in which I would set it out if I was going to set it out. Likewise, things on accessing legislation, you may say, look, my preference is to go through AustLII. I would probably suggest that you should go through the authorised channels, but realistically, I go to AustLII first up, I've got to be honest, most times. So there are certain ways of doing things, but if you go to the unauthorised source first up, then you might just put a little rider to say that you will double check this by referring to the authorised service, particularly if you're going to present something in a court situation. So in terms of accessing legislation, I go to AustLII first. I'll go to Queensland legislation for the Queensland legislation authorised, or I'll go to the legislation registrar, the Commonwealth Register of Registrations, for the authorised Commonwealth registration or legislation. Sorry. I don't usually go through other sources such as the paid services, but you can. You can also go through JADE, which is a free service. These are all options that are available. And what I tend to find is that people work out something that works well for them. And that's why I'm not prescribing what you should do, other than be aware of the difference between those resources that are authorised and those that are unauthorised. I hope that makes sense. Now, Mackenzie, does that answer the question that you'd asked early on?
Yeah, I'm just having a bit of trouble trying to find the specific legislation for what you're trying to solve sort of thing. Is there any way around that or doing that?
Yeah, now I must be honest, I forget the name of the website, but I do refer to it in one of my legal research videos, and someone might be able to remind me of this. I think it's LAWLEX, LAWLEX, please refresh my memory, those of you that have watched the videos more recently. It's a service where you can type in, say, a word, and it will give you a list of legislation relevant to that topic. And I think the example that I use in the legal research video relevant to this point is, let's say that you have an issue to do with a will, someone's will. They've died, there's a dispute between family, and you know that there's some legislation on this, and you look out alphabetically, there's no Will Act of Queensland, then you think, well, maybe it's the estate law, so you look up Estate Act, there's no Estate Act. And finally, and Abby, thank you very much for confirming, it is lawlex.com.au. You can use that website to determine that in fact the legislation that you're after is the Succession Act, if you're dealing with the person's will. So Lawlex, I think, might be the quick way to go. It's remarkable how quickly, I guess, being in practice for so long, you tend just to go to these things. I don't use Lawlex because I'll tend to know what I'm looking for. But I think that would be a very good place to start. Hopefully that will answer your question and provide you some guidance, Mackenzie. Excellent, thank you. All right, Gareth says, does the second assessment need to be in essay format? No, it doesn't. You're welcome to put it in essay format if you wish, but I'm going to encourage you, and I do encourage you, to be inventive, to use something that works for you. And again, the emphasis is on a practical document, something that will help you immediately answer the third assessment, which is the take-home paper. But beyond that, assessments that you might do in law for your later studies in this course, or in practice, whether as a lawyer or in whatever field you happen to be practicing in, accountancy, engineering, whatever. Having the toolkit is meant to be your go-to document to help you to solve legal-based problems. And excuse my voice is going, a lot of talking today. So some good questions coming through. Any other questions about the second assessment, the toolkit? All good? All right. And you can consult with your peers at your discretion. Just be careful not to collude with them. If you do refer to material, please ensure that you refer to the Australian Guide to Legal Citations. And whilst you may not include something in, for example, essay format, if you do refer to material, if you've sourced it elsewhere, I would expect that you would use footnote referencing generally to acknowledge that and to refer to it. Okay, all good? Well, let's kick on. Last week, we were talking about issues to do with statutory interpretation. This week, we're going to start with issues to do with resolution of uncertainty in contracts. Let's have a very simple example. You're a first-year lawyer, or you're a lawyer assisting at a neighbourhood dispute, at a neighbourhood legal service. A client comes to you and says, look, I want to know whether I have to pay a bill. The circumstance is this. I asked someone to come out and quote on cleaning my house externally. I received the quote, I accepted the quote, and the contractor said, I can come out and deal with it on Saturday. You're nodding, saying, all right, I've got it. And what happened? Well, the contractor came out on Saturday, did the work. You happy with the work? Yes, I'm happy with the work, but I don't want to pay. And the reason I don't want to pay is that I've read some contract law, and I understand that if a contract is uncertain, then it's void and there's no obligation on me. And I think it's uncertain because the house cleaner said, I'll come out on Saturday, and didn't specify, the contract didn't specify any date, and we didn't agree on necessarily this Saturday. He just said on Saturday. Now, your client is probably very unmeritorious, yes? You've got a client and you just want to say, just pay the bill. But what is your obligation legally in terms of representing this client who's trying to get out of a bill that the client should realistically pay? And secondly, is there a contract that is uncertain? And therefore, does the client have the legal right, although there's no moral right, to say, I'm not paying the bill? Does anyone have any thoughts in relation to those issues? Firstly, ethical issues. Are there any ethical concerns about giving advice to this client? Conversely, are you entitled to say, I don't like what you're telling me. I think you're a rotten scoundrel. And not that you necessarily use those words, but you use something to the effect of, I choose not to represent you in these circumstances. So Mackenzie says, no, they provided a service, they were happy, they should still pay. So the preliminary question, so Mackenzie says, my advice to the client is pay the bill, but would you, and firstly, would you advise the client, or would you say, I don't want to have anything to do with you. I don't like you. Are you allowed to say that? Tim says, I would think you have the right not to represent. Any other thoughts? There's a slight difference here between the ethical obligations for a solicitor and a barrister. Just to give you a heads up, the reason I'm raising this issue first up is that you must always consider ethical issues when answering any legal question. It must be foremost in your mind. You may not necessarily refer to the Australian Solicitor's Conduct Rule or rules or the barrister's rule in your answer, or either of them, but oftentimes you should. And so ethical issues are always part of a legal question. Keep that in mind. Ethically, for barristers, there's a thing called the cab rank rule, and it means that irrespective of what you think of the client, the barrister is duty bound to accept the case. So it's a barrister is not entitled to say, no, I don't like people who are charged with interfering with children, so I'm not going to represent you. You don't have that right. Subject to this, there are some exceptions, and one of them is if you don't practice in criminal law, you can say, I don't practice in criminal law, I'm an environmental law barrister, or I can't take on your case because I've got commitments on that day. So things of that nature are always exceptions, but generally speaking, a barrister must take on the case. It's a little different for solicitors, but generally speaking, the legal obligation on you is to take on the case, even if you don't like what the client has to say, or you don't like the way that the client presents. So remember, of course, that your role as lawyers is in the administration of justice, and the general principle is that everyone is entitled to argue their case, argue their position, and have lawyers to assist them in that regard. Now, of course, that's very different to you saying, my advice very firmly is that there is no uncertainty in this contract and you should pay. And if you choose not to pay and you're sued, you will lose. That's my advice to you. You accept it or you reject it. If you reject it, I will argue as best I can on your behalf, but I'm not suggesting in any way that we will win. Now, you'd actually rarely get a lawyer being so categorical in the advice. Usually it's much more of a grey area than the black and white. Rhonda says that there may be issues whether you know the person, for example, or perhaps they could suggest alternate advice. So these are some issues. I'd like you to look at that during the week, and if you haven't already built something into your toolkit, if it's not too late, about ethical issues, you should always consider that. And for your third assessment, the take-home paper, make sure that you at least consider ethical issues and consider ethical issues in any legal paper that you answer throughout the rest of your course. Again, I'm not saying, please don't misunderstand me, I'm not saying that you must include something to do with ethics in every question There'll be many times when you answer a legal question without referring to the legal obligations or ethical obligations. But what I'm suggesting is that you should keep this as almost a preliminary thought, as a foremost in your mind. What are the legal, ethical issues here? And if there are any, how do I deal with them? So let's come back to the contractual issue. Is there uncertainty here? Well, let's play devil's advocate. Let's say we're in court, I'm acting for the homeowner, and I'm saying in cross-examination, well, if you say that there was certainty as to the contract, what do you say was the date that it would be completed? Now, the answer would be Saturday. You say, which Saturday? Well, we didn't say which Saturday. I just said on Saturday. So that could have been any Saturday. Well, it could have been. I meant, well, don't tell me what you meant. Tell me what you said. Could it have been any Saturday? Yes, it could have been any Saturday. All right, so therefore it's uncertain as to what day it was going to be. Well, yes, if you put it that way, and then you argue, well, there's got to be uncertainty here, Your Honour. Do you see what I mean? And that's the role of counsel, to try and paint things in that manner. Now, what I've given you is a very extreme example, and the courts would not have a bar of it. You know, the homeowner would lose in these circumstances. But the court may have to go through a process of completing some gaps here. So when the court comes to its decision and says, we do have a contract, the contract was sufficiently certain from my perspective to make it enforceable, therefore the homeowner must pay, and I'm going to, as it were, fill a gap here, which I believe is reasonable and fair, to say that when the home cleaner said, I'll be out on Saturday, that meant this Saturday coming, and that was accepted by the homeowner. So therefore, the issue to do with the time for performance of the contract was satisfied through that exchange. Have a look at the list on page 273 of your text, and you'll see that in that list at the bottom of the page, underneath the case study for Scammell and Houston, that there is a list of things that courts will imply in particular terms into a contract if all of the following requirements, that is all of them, are satisfied. The court will imply a term if it's reasonable and fair, if it's necessary to make the contract viable, that the term is so obvious that it goes without saying, the term is able to be expressed clearly, and the term is consistent with expressed terms. In doing so, the court will adopt, you'll hear this phrase occasionally, the officious bystander test. The officious bystander test, which is if a bystander, someone looking from the side, had been present during negotiations and had asked the parties whether such a term of the contract was relevant, and the parties would have said, yes, of course. So, for example, another silly example is if the quote was for $1,500 and after performance of the contract, the homeowner doesn't tender Australian dollars, but tenders, I don't know, the dollars of some other country, which are in fact worth much less than $1,500, the homeowner would lose because the officious bystander, when asked, well, what do you think they meant? Do you think they meant Australian dollars? The answer would be, of course, they meant Australian dollars. We're in Australia. That's what they would have meant. So do you see what I mean? So even though the contract was for $1,500, the court would read into that it was Australian dollars, and it would use the objective test, that is the test of what would an officious bystander have thought by asking that question of the parties at the time. Do you mean Australian dollars? Yes, of course we mean Australian dollars. Does that all make sense? Okay. All right, so Scammell and Houston is a case that you will come across in contract law, but the concept of the objective test for determining what the parties meant is something that you will see very often throughout your legal career and studies. When we talk about the objective test, we can contrast that with another type of test for determining something. What's the opposite in law of the objective? Rhonda's got it. First in. Well done. Subjective. So when we talk about subjective, we are really stepping into the shoes of the person to determine what that person actually meant, as opposed to objective, which is where the officious bystander makes a determination as to what the parties would have meant. What was the objective understanding? Okay. With your legal work, you need to be certain in terms of your writing. And the silly little examples that I've given you so far go to highlight one thing, and that is that contracts need to be drafted in a simple but highly effective form, and they need to cater for a number of potential circumstances. So as you're drafting something, not only are you attempting to draft in plain English, in a plain language that is readily understandable, but you're also thinking about what are the gaps, what's missing, what do I need to ensure that there is a minimal degree of room for argument and requirements for interpretation. Now, have a look at page 248 of your text, if you would. And you'll see at the bottom of the page, when you get to it, a quote from Ravenseft Properties against Davstone Holding, 1979, 1 All England Reports, 929. Just take a moment to read that. Those of you that are watching this as a recorded session, perhaps you could go to your text and read it. I won't read it in full. All right, so what we have there is an example of some wording that was very common in commercial documents, less common now. The reason that I say that it's less common now is that we don't draft in this painful manner. You can see the intention. The intention of the drafter was to say, well, I don't want to leave any stone unturned. I want to ensure that there is absolute certainty. But in the course of trying to create absolute certainty, they've created an unreadable document. So what's the obligation of the tenant? To repair, renew, rebuild, uphold, support, sustain, maintain, pave, purge, scour, cleanse, and it just goes on. One of the difficulties in that type of drafting is that if you happen to leave out one word, then it's more likely that the document will be struck down or not applicable to that because you left out that word when you clearly intended to put in all other words. So the purpose of drafting now is to do so in a way that is clear but non-repetitive. One way to do that is to use definition clauses. You can also rely on some common sense, and importantly, you can have access to the Acts Interpretation Acts, both federal and in your state. A few years ago, I wrote a redrafting question. What I propose to do now, and this I don't think is in your study guide, but I'm going to share a document with you, and I'm going to ask you to take a moment to read it and then try and rewrite it in 100 words. I'm going to give you 5 minutes for this exercise. So those of you watching as a recorded session, this is going to be some dead time, as it were. And I won't read it, but I will show you this on the screen. So I'm going to give you 5 minutes. You'll look at this thing and you'll say, well, how am I going to rewrite this in 100 words or less? You might be able to do so in 70 or 80 words. But before I put it on the screen, just a couple of reminders. Short sentences are always useful. Definitions might be useful. And do write in the active voice. Generally, that's a more efficient, quicker way to write. And after 5 minutes, we'll see who comes up with the closest best answer. So, all ready to go? I'll share the screen now, and I'll just enlarge it. Can you see that? Starts with every student who is enrolled in the university. Mackenzie, you can see that? Thumbs up? Yep, okay. All right, I'll be quiet now for 5 minutes. Thank you. All right, well, I'll put you out of your misery. Sorry. I know some of you were very close to finishing that task. But just as an idea, can you tell me how did you go in terms of working through that issue? Was it painful or did you feel it was possible? Well, Peter's already got one here. Okay. Every student enrolled in this university is subject to the university ethical and plagiarism standards. If found in breach, they will be subject to disciplinary action. The accused will be afforded natural justice to the investigation and findings. Very good. Did anyone else come up with anything? And I know I cut it off very abruptly. My apologies for that. Any other thoughts? Mackenzie said it was possible, but was very overworded, which it was intentionally, of course. So when you're dealing with that, and Rachel said, I got halfway through, it was difficult to weed out the facts from the rest. Tanya said, I would have just added definitions of university student and a couple of others. Good way of thinking about it. So we're seeing some different approaches to the task. And one of the, to Peter's answer, says Tanya, one of the things that you might consider doing in those situations is trying to use a highlighter to identify the key words, or putting them in a separate document and trying to write in the active voice short sentences. So I think Peter was right. The first thing was to identify that the university may impose ethical standards. That would be upon enrolled students. That if a student is found guilty of behaviour adverse to the standards, the Vice-Chancellor may discipline the student accordingly. The disciplinary committee might hear evidence, and the student will be notified in writing as to the day of time of hearing, and the university reserves the right to investigate the matter comprehensively, and the student has the right for legal advice and may appeal the decision made as a result. So that's kind of an answer, which is a little disjointed, but you get the idea. So the purpose of that little exercise, and I'm sorry it was a little painful, was to have you start thinking about how to reword documents that are not well worded, to make them simple, to write in the active voice, but at the same time to create a degree of certainty and understandable documentation. And as you would have seen in that material from the earlier draft, sometimes it's very difficult to come up with something that is clearly understandable. All right. Now, when you're putting your skills together, you need to also be in a position to take something that is very well written and then expand upon it. Now, I'm going to ask if you could do this for me, and that is find the Civil Proceedings Act 2011, Queensland, and have a look at section 8. And just let me know when you've found that, and just make a note of, or tell me how you found it as well. We're after section 8 of the Civil Proceedings Act, Queensland. Okay, so Megan's got it. Just wait for others to. Timothy went to Legislation Queensland. Tanya's got it. Megan, Tanya, where did you source the legislation? There's no right or wrong answer here. Legislation Queensland. Ostley. Okay. All right. So the legislation simply says, Section 8, equitable damages. Rhonda went to Queensland Parliament. So Section 8, equitable damages. If a court has jurisdiction to hear an application for an injunction or specific performance, the court may award damages as well as or instead of an injunction or specific performance. Now that is really good writing, but I'm now going to ask if you could tell me what it means. Now, bear in mind that this was an actual question from, I think, last year's paper, take-home paper. So that's the sort of thing we need to be able to decide. So firstly, can anyone tell me what we mean by equitable damages? Perhaps you can contrast it to something other than equitable damages. What does the word equitable come from? Any takers? We're quiet tonight. Equity, thank you. I thought that was a nice, easy introduction. And when we talk about equity, we would contrast that to what? Legal, yes. Financial, not so much. Money, not so much. The contrast that I'm really looking for here is the contrast between that which was equitable, the contrast, equitable versus common law, equity versus common law. So do you remember that distinction that we talked about early on? And it is a remedy, and we'll get to that shortly. But when we talk about equity, we're talking about that branch of the law that was created through the Exchequer. Remember, where people would petition the king for pardons or special consideration, as opposed to the black letter law, which was the common law, which was the legal, if you like. So when we talk about equity, we usually contrast it with the common law. And it's very confusing because equitable decisions do in fact become part of the common law. So I appreciate that you can find that distinction difficult. Now, the next issue is this. Rhonda said remedy, and that's a really good word. So damages is a remedy. Would we agree with that? Okay. And what other types of remedies are there? Damages is a remedy. What other remedies are there? Reinstatement of position, injunction, specific performance. Tim said specific performance. Gareth said injunction. Tim says enrichment. So they're all good ones. The main ones that really spring to my mind are specific performance and injunction. Are specific performance and injunction equitable or legal remedies? We'll give you a straightforward choice. Equitable or legal? Specific performance and injunction. One vote for legal. One for equitable. Tim says both. So at this stage, we've got 1, 1, and 1. Specific performance and injunction, equitable or legal, or both. We've got 2 votes for both, another vote for equitable, another vote for both. All right, I'm going to come in with my answer here, and they are equitable remedies. So injunction and specific performance are equitable remedies. They're not legal remedies, they're equitable remedies. I know this is going to get really confusing for you, but we'll keep working through it. Now, the reason that I say they're equitable is that they spring from the equitable jurisdiction created almost in, if you like, in the Middle Ages in the Exchequer. And it was based on what's fair. So when parties in medieval times had a dispute before the court which applied black letter law, the court was able to say, you don't have a case, or yes, you do have a case, and I will compensate you with the remedy of damages. But that's all that the courts could do. When it came to the king's discretion, it was much broader and it was based on what's fair. They could say, no, you can't do that, or you must do that, which is essentially injunction or specific performance. So they're equitable remedies. But here we have this hybrid of equitable damages. So when it says a court has jurisdiction to to hear an application for certain things, it may do something as well, is how we read that. So what do we mean by if a court has jurisdiction? What does court mean? And what does the word jurisdiction mean? How would you find out? Jurisdiction, Megan's got a great answer to that. Jurisdiction is the limit of a court's power. Perfect. In other words, if you made an application to the magistrate's court asking for the court to issue an injunction to restrain the construction of a dam, then the court may say, we don't have power for that. That's not within our jurisdiction to do that. You'll need to go elsewhere. You may have to go, to example, the federal court to obtain the injunction to stop the bulldozers coming in to construct a dam over what is an area of, natural wetlands or Ramsar wetlands, for example. So jurisdiction is the limits of the court's power. And what do we mean by court? Now, bear in mind, this is a Queensland Act. So does it apply to all courts that happen to decide matters in Queensland? Does it only relate to Queensland or federal courts? Or can it be both? So when we talk about courts, we're talking Queensland, federal, or both. We've got one vote for both, another for the nature of the matter, one vote for Queensland, unless appealed to a higher court, presumably such as the High Court, another vote for Queensland. Here's where it gets tricky again. It applies to all Queensland courts and arguably also applies to tribunals, but really it only applies to courts in my view. There is a thing called cross-vesting jurisdiction. This came in, as it were, across the board in 1987, and it allowed Queensland courts to have some degree of jurisdiction in relation to federal matters and vice versa. So the cross-vesting jurisdiction really clouds what would otherwise be a relatively straightforward concept of this is a Queensland law, this only applies in Queensland courts, not federal courts. It doesn't work as simply as that. So those of you that said both, you're probably right, although strictly the section applies most certainly to the Queensland courts. Well, what are the Queensland courts? What are the hierarchy of courts in Queensland? What's at the top? Peter says section 109 of the Constitution would overrule. Okay, to answer the question, we're getting a lot of votes for Supreme, yes. What sits below the Supreme Court? In Queensland, District, and below that? Magistrates, are there any others? All right, what about QCAT, which is a tribunal, not a court, but it looks like it. Children's Court, that's a good answer. Planning and Environment Court. And what about the Court of Appeal or the Supreme Court in its trial division? Gareth came in with Court of Appeal. So we need to know what courts we have in Queensland. Just to give you a brief overview, we have at the top the Supreme Court, but that's in two divisions. We have the Appeal Division, which is the Court of Appeal, and also within the Supreme Court, we have the Trial Division, which is where typically a single judge of the Supreme Court will hear a matter. So an appeal from a single judge in the Supreme Court is to the Court of Appeal, which is also part of the Supreme Court. QCAT works a bit the same way. If you appeal the decision of a member of the tribunal of QCAT, it goes to the appeals tribunal of, it goes to the QCAT appeals tribunal, which is still internal, and from there it goes to the Court of Appeal. Okay, so, and the Planning and Environment Court is a separate court, but it is administered through the district court level, and the judges of the Planning and Environment Court are also district court judges. So it applies to all of those. Children's Court generally works with magistrates, but it can apply at a district court level as well. So you can see that when you look at this simple Section 8, there's a few things that come to mind. You've got to understand and be able to explain what we mean by equitable and contrast that with legal or common law. You need to understand what we mean by damages and contrast that with other forms of relief. Now, identify damages as a remedy and say other forms of remedies are these. When we talk about courts, we need to identify what are the courts and whether they're courts which are Queensland-based or those that are federal-based, or both. Now, what do we mean by an application? What's meant by an application? There's no magic in that. It's really just asking the court for something. But in order to know what we mean by an application and how it works in practice, you'd need to know some of the practical sides of things. So when we're talking about civil procedure here, does anyone know where the rules around civil procedure might be contained? Tanya's onto it in a flash. Very good. It's the UCPR, which is the Uniform Civil Procedure Rules. So from a practical perspective, that's a very important. I've got it behind me there. You might be able to see it. It's one of the thick documents, binders. The UCPR, the Uniform Civil Procedure Rules, and in that you'll see what's meant by an application, and it'll refer you to the regulations, which shows you the form. Now, just also remember that this section 8, is subject to other sections around it. So if you're answering this question, you'd need to consider other sections around it. So for example, in Section 7, subsection 3 of the Civil Proceedings Act deals with the distinction between legal and equitable remedies, and basically says that where there's a conflict between rules of equity and rules of common law, the rules of equity prevail. Now, do you remember we talked about that in week 3 or 4? We were talking about equity versus common law. What if there's a conflict? Equity prevails. That is now based in statute. I know I'm moving fairly quickly, but the idea is to say we've been through the exercise tonight of taking something that was very wordy and drilling down into something that was much more manageable. Now we're doing the opposite, taking a very well-worded piece of legislation and trying to identify what it means in practice. In order to answer this question properly, you also need to understand what we mean by the term injunction. What do we mean by the term injunction? What does injunction mean? We know it's an equitable remedy. We discussed that just a moment ago, but what does it mean? If you're applying for an injunction, Peter says, Gareth says, get them to cease. And Peter says to stop. Those of you that watched Sea Change, do you remember that? Sea Change? I'm showing my age now. Only the older ones would know Sea Change, but there was a scene where they were trying to stop the bulldozers. What they really needed to do was go and get an injunction. So to stop a process. To complicate things, injunctions can either be mandatory or prohibitive. Mandatory is actually to force someone to do something. A mandatory injunction is a positive injunction to do something. But usually when we're talking about injunction, we're talking about a prohibitive injunction, which is to stop a process. So in order to answer the question, what does Section 8 of the Civil Proceedings Act mean? You'd need to know what is meant by an injunction, where do we find the term, how is it used in practice? What's meant by the term specific performance? Bear in mind, this was all part of the exam question last year. So this is the sort of level of detail we need to get to as part of our legal research. What do we mean by specific performance? The words themselves actually give a hint to the answer. To do a particular thing, exactly, says Tim. I agree with that. Specific performance means do a particular thing. So if, for example, you have a contract for the purchase of land, it's a beautiful block. It's by the river. It's got some magnificent trees. It's just absolutely perfect. And you've signed the contract, and for no good reason, the seller says, I refuse to settle. You could sue for damages, but it's not the same having the extra money to go and buy an inferior block. You wanted that block because you've already paid the architects to design a house and it's just perfect. So what you can do is apply for an order for specific performance, which is essentially compelling the seller to complete the contract. Sky says contractual duty. Exactly. All right, so we need to know what we mean by specific performance. What do we mean by damages? We know that damages can be legal or equitable. In this instance, we're talking about equitable damages. Damages, a loss, yes. Money, yes. Okay, so it's compensation. Monetary compensation is damages. Now, how is it possible, if you look at Section 8, it's, you then ask yourself the question, how is it possible for a court to make an order together or separately? How can a court, if you look at Section 8, it says the court has, if a jurisdiction to hear an application for injunction or specific performance, the court may award damages as well as, or instead of, an injunction or specific performance. So how can the court order damages and an injunction, or damages and specific performance? How can that happen? Can anyone give me an example? Yes. Peter says, you owe me $100,000 and you must give the property to me. Tanya says, may order specific performance and award damages to recover legal fees. In the example I've just given, yes, you must complete the contract and pay the legal fees, for example. So these are things that you can do. It is possible for these things to do together. And damages can be legal, can be equitable, can be both. Specific performance and injunction are both equitable remedies, and the orders can be made on an interim or final basis. What do we mean by interim and final orders? What does that mean? Ability to appeal? Stages. Stages, says Tim. Yes, I agree with that. So it may be that when you make the application, all you want is the order for specific performance and damages, and that's the end of it. Or it may be that you're looking for an order for an injunction to stop them from printing the defamatory material. We'll get that injunction to stop them, and then we'll go and we'll argue the case as to whether in fact it was defamatory, what they did. So you may need the injunction to stop them. You may need the injunction to ask for an order to search something, or to have some property or other material ready to pay a damages award in the event of you being successful. So you've got to identify that this section refers to orders that may be made on an interim or final basis. You need to consider always, in answering a question like this, the ethical obligations, and you may ask yourself whether there are any ethical obligations in the Australian Solicitors Conduct Rules or the Barristers Rule, as we discussed early on tonight, because you'll do that in every question that you answer. And you'll consider the costs ramifications for this as well. So they were the sorts of things that I was looking for from students in answering that question last year. I hope that I haven't scared you off too much. The intent of tonight's session is really to motivate you to start to look at things very critically. Wordy things, look at them critically to drill them down, and what are simple things apparently to think about how simple ideas might actually be complicated by looking at them with a more legal eye. Any questions from tonight's session? You've all been very patient, very good. All good? Okay. All right, well, we'll wrap it up for tonight. Thank you very much, and we will see you next week. And if you haven't done your assessment, please upload by Thursday. All the best. See you then.